Good morning. This is Russell Berger, and I'm here with April Rancier. We're going to get started in a minute or two to discuss paid sick leave, what happens next. Good morning, and welcome to the Employment Review. Today we will be covering paid sick leave and what happens next, where we'll be discussing the recently passed Maryland Healthy Working Families Act. During the course of today's webinar, if you have any questions, please feel free to submit them through the webinar software. My name is Russell Berger, and I am the chair of the Labor and Employment Group here at Offit Kurman. I work with clients of all sizes to craft pragmatic solutions to any obstacles that they encounter. This month, for literally all employers in the state of Maryland, that challenge is sick and safe leave.
My name is April Rancier. I'm also an employment attorney here at Offit Kurman, and I work to protect companies of all sizes by ensuring that their employment practices are compliant with ever-changing employment laws, and that includes this new sick leave law that Maryland has recently given us all. And that's why we're obviously here today to try to help you all figure out what needs to be done with respect to that law. All right. So as you all know, we have this new sick leave law, and business owners are going to need to deal with this relatively quickly. So today we want to try to help you all by covering the requirements of that law, the impact of the law on businesses with respect to the business's existing leave policies, and also strategies for adopting or revising any current policies that you might have in order to be compliant with the new law.
This is probably the simplest and most basic point in the entire law. All employers in Maryland need to provide sick and safe leave. If you have 15 or more employees, then sick or safe leave must be paid at the pay rate the employee normally receives. If you have less than 15 employees, the leave can be unpaid. Now, the law is not very detailed as to the definition of employee for purposes of calculating whether you have hit the 15 employee threshold or not. But that being said, I think the definition of employee is pretty broad, and for example, it doesn't exempt part-time employees or people that are working different schedules. I think anybody that could be loosely considered an employee is going to count towards that 15 employee threshold, at least until we have some more detailed regulations from the state that tell us otherwise.
In terms of what sort of leave is kind of covered under this law, you will see some similarities to the Family Medical Leave Act. For example, employees can take leave under the new Maryland sick leave law to treat the employee's mental or physical illness, injury, or condition, as well as to care for the employee's family member who may have a mental or physical illness, injury, or condition that needs to be treated. So the employee can take leave for either themselves in that situation or for their family member. the employee can also take leave under this law to obtain preventative medical care for either the employee or the employee's family member. And the employee may use this leave for the purpose of maternity or paternity leave. And one of the types of leave that are covered that you maybe wouldn't typically think of in terms of why an employee might use sick leave is to allow the employee to be absent from work due to domestic violence, sexual assault, or stalking against the employee or that employee's family member. And that leave also has, in order for the employee to take leave for that purpose, the leave needs to be used by the employee to either obtain for the employee or the employee's family member medical or mental health attention treatment, services from a victim services organization, legal services or proceedings, or leave for that employee to relocate due to the incident that the employee is experiencing.
So far this morning we've talked about the general requirements as to what needs to be provided and what exactly sick and safe leave is. And that might be background that you've gathered just from reading articles in the newspaper or online. And I know some people who might be attending this webinar maybe attended our partner Howard Kurman's telebrief that included a discussion of sick or safe leave yesterday. But now we're going to get into a lot more of the detail of what this law is actually about. And this is important because no matter what your existing policy is, these details are going to have to be incorporated into an existing policy or replace an existing policy. And this is really where the rubber meets the road. So with respect to how much leave is required, the statutory provisions are written in somewhat of a backwards way, where it talks about putting minimum caps that can be put into place. But really what we do know is that all employees can earn up to 40 hours of sick or safe leave per year. And if sick or safe leave is accrued throughout the course of the year and not just awarded at the beginning of the year, it must be earned at a rate of at least 1 hour for every 30 hours worked. And that's easy enough to track for hourly employees. For exempt salaried employees, the assumption is of a 40-hour work week. So if you were using the minimum threshold and you had an exempt salaried employee, they would be earning 1.33 hours of sick or safe leave per week based on the assumed 40-hour work week. Now, while April will be discussing the year-to-year carryover options in the next slide, for right now it's important to know that if leave is accrued throughout the year, which is how a lot of employers do structure their current PTO policies and not just awarded at the beginning of the year in a lump sum, there is going to be a carryover requirement, which is how you get to the next two bullet points on this slide, which show 64 hours. Because you can't get to a 64-hour cap without carrying over some of the 40 that could be accrued in year one. However, the bank of sick or safe leave hours can be capped at 64 hours, and even though you might still be accruing to get to that 64-hour cap, employers can also cap annual use at 64 hours.
So some of you are sending in questions. Please continue to do that. We'll do the best to answer them as we're going through the presentation, but if we're unable to do that, we will certainly try to address those at the end of the webinar or follow up with you after the webinar to answer any specific questions. So please keep sending those in so that way we can answer them as soon as we can. So in terms of the carryover options that the law provides, the law essentially allows employers to choose from two different carryover options. The first option is the option that provides for carryover, which is what Russell was just speaking to. So if the leave is accrued over the course of the year at that minimum rate of 1 hour for every 30 hours worked, then up to 40 hours of accrued and unused time must be carried over. So under that option is where you get into a circumstance to where you might hit that cap of the 64 hours that Russell was speaking to. The second option is most likely the simplest in terms of an administrative burden of tracking and keeping track of the sick leave that the employees are taking, and that is that if the 40 hours of sick leave are granted to the employees at the start of the year, then the employer is not required to carry any unused sick leave over to the following year.
And, another point to note about that is the law does make clear that there is no requirement that sick or safe leave be paid out upon termination of employment. So the general rule in Maryland is that if you offer leave and you have a statement in your handbook or in your leave policy that says, general leave is not going to be paid out upon termination, then that's sufficient and you don't have to pay out any PTO upon termination. This law does not change that at all.
And with respect to either option, as with most aspects of this law, a really important piece of it is once you determine what is going to be a compliant policy for your particular business, is to make sure that that policy is documented in a handbook or written sick leave policy that's distributed to the employees, and that you have a way of tracking that the employees actually receive that. Documentation is going to be really important here, especially until we get a little bit more guidance in terms of how this law will be treated by the courts.
The law also includes some minor limitations on when sick and safe leave can be used. First, leave can be prohibited for the first 106 calendar days of employment. This is particularly important for seasonal workers. So if you think of the shops on the boardwalk at Ocean City that might hire college or high school kids to work for the summer, they wouldn't necessarily have to allow any of their employees to use sick or safe leave, provided they didn't cross over the 106 calendar day threshold. However, leave would still be accruing during this time. So even though an employee might not be permitted to use their sick or safe leave yet, they would still be accruing or obtaining their sick or safe leave so that as soon as they cross the threshold, they'd be eligible to use it. Also, the leave, even though the leave is not permitted to be used during the first 106 calendar days, if the employee were to return to work within 37 weeks, the accrued leave is restored to the employee. So they could earn it one summer and then be able to use it the following summer. Second, for foreseeable absences, and while that could mean a lot of things under this law, I think the most obvious example would be planned doctor's appointments or appointments you schedule ahead of time. Employers can require employees to provide up to 7 days of advance notice. In contrast, if the leave is not foreseeable, which very well may be more common under this law and fits more within the typical idea of sick leave that we as employment lawyers think about, employers can require notice as soon as practicable. The literal word in the law is practicable. I don't think that's particularly great guidance for employers, and I don't think it's a very functional term, but basically what that means is that as soon as is reasonable. And so you would want to craft your leave policy to include that requirement so that while you're not going to be able to prevent an employee from taking unforeseeable leave, at least you can require the employee to let you know as soon as is reasonable to do so. One final point on when leave can be used is that leave can be denied if the employee fails to provide the required notice. Now, obviously, like I just mentioned, if it's an unforeseeable absence, there's not really an advance notice requirement. But for the occasions where it is, leave can be denied if the employee fails to provide that required notice and the absence will cause a disruption to the employer. Again, I think ultimately regulations will be issued by the DLLR that will help us understand what that means. But because the term in the statute is disruption, and that can mean a lot of different things to a lot of different employers.
We've gotten a few questions about what that statutory term disruption actually means. And like Russell said, that's going to mean a lot of different things to a lot of different employers. So if you have any specific factual questions related to your specific scenario, we're happy to answer those via phone or email after the webinar. But it really is just going to be, trying to make a good faith effort to be as compliant as possible and to document your efforts to do so. And then once we get some regulations, I think we'll have a little bit more guidance in terms of what that and other terms in the statute actually mean.
And borrowing from other employment laws where they use terms like hardship and reasonable, and these all become very fact-specific and very dependent on the employer and the employee and the employee's role. So, for example, in our law firm, we have administrative support staff, and if one administrative support person were to call out sick, that would, in theory, be some level of disruption, but that work can then be allocated across other administrative support staff. So my feeling on it is that's unlikely to be the type of disruption that would satisfy this definition. But again, it'll ultimately be very fact-specific, and hopefully we'll have some guidance on it in the near term.
All right, so turning to what kind of verification employers can request to make sure that the employees are actually using the leave for the reason that they're requesting it for. An employer can require that an employee provide verification in situations where the leave was used for 2 or more consecutive shifts, or when the employee uses leave between days 107 and 120 of employment, if that employee agreed to provide verification at the time of hire. So again, that piece that states that you can request a verification if the employee agreed to provide it at the time of hire goes to the documentation and the importance of having a written policy that's compliant with this law, and making sure that employees are on notice of what their requirements will be to provide these sort of verifications. If an employee fails to provide verification, then employers are permitted to deny future sick leave requests for that same reason. So what this means is that if the employee is out for a knee injury and requests leave under the sick leave law to receive treatment for that knee injury and misses 2 or more consecutive shifts because of that injury, but fails to provide documentation at the request of the employer from a medical provider of that injury, then the employer can then deny that same employee's request to be out for another doctor's appointment for that same knee injury. So that's how that will work in terms of the verification and the ability to deny subsequent requests for leave. Again, the verification requirement should be memorialized in either the handbook or the sick leave policy that's going to lay out the entire policy for your company.
This law also requires records to be kept of both the leave that has been earned and the leave that has been used. In this respect, I don't think this should really be a drastic change for employers that currently have some form of paid time off. However, I do think you should consult with your payroll providers to ensure that this is properly tracked and recorded on your system. So, for example, presently, I would imagine that most employers that have some form of PTO have a tracking system that's connected to their payroll. And I think this is how sick or safe leave should function as well. And in some instances, and we'll talk about this in a little bit, you might just be modifying your existing leave policies and not creating a brand new bucket of leave. So in any event, I think it's a good idea to get with your payroll providers and ensure that you're properly tracking and recording time, and you have the software and the capability to do so. This is also a good idea because the law requires employers to either provide a statement of sick or safe leave balance along with or as part of each pay stub, or to provide an online portal where employees can access their sick or safe leave balance. So not only do you have this tracking and record-keeping obligation, you have an affirmative obligation as an employer to keep employees aware and up to date as to what their balance is. So again, I think the payroll system is the most efficient and effective way to accomplish that requirement. And also, it's important to note that if you do not keep accurate records, the law actually has a provision that says you are presumed to have violated this law. Number one, you're obviously violating the law because the law says keep records and you haven't. But the presumption really applies to the question of an employee challenging the amount of leave that they have, or why weren't they paid for leave that they thought they had earned. If you don't have documents, then you're going to be presumed to have been in violation and to owe that employee penalties and damages. Now, as a practical matter, if you came to me and said, hey, I'm getting sued for this, what do you need to help build my defense? I would ask for the documents and these records. That'd be the first thing I would ask for. So while it is a requirement of the law and it does carry with it the shifting presumption, I also think it's important from a practical standpoint that you have this track, because that's how you're going to be able to best defend yourself anyway.
All right, so in terms of what sort of notice and information needs to be provided to the employees about this new law, the state will be providing a poster at some point in the future that will need to be posted in a similar place as to where your wage posters are, so that employees can easily see that. Notice should also be provided, and this can be in terms of a new policy that's distributed to the employees that we've talked about, or in an updated handbook, but that notice must include how the leave is accrued, whether the employer is choosing option 1 that we talked about earlier or option 2 for specific employees, the purpose for which leave is available, meaning what reasons the employee can use the leave for, and a statement that states that the company is not permitted to retaliate against an employee for taking sick leave or for requesting sick leave, and also the employee's right to report a violation of this new sick leave policy. Again, I mean, like Russell and I both said several times during this webinar, documentation is going to be important here. So as far as the notice that is distributed to the employees, we recommend that it's distributed in a way that employers can confirm that the employees received it and signed off on it.
It seems unlikely to me that the DLLR will be sending out investigators to review people's paid sick or safe leave policies, and frankly, that's not really contemplated by the law. Instead, complaints under this law will originate with employees filing administrative complaints, at which point the law provides a mechanism for the DLLR to investigate, and then ultimately, if it finds any type of violation or potential violation, to mediate and try to resolve the matter informally. If informal attempts at resolving a dispute fail, the DLLR may then issue an order finding a violation. And when it issues an order finding a violation, it's going to include in that order penalties. Certain penalties are mandatory and will certainly be included, and that includes the full monetary value of any unpaid leave. So if someone makes $20 an hour and they were shorted 1 day of leave, according to the DLLR, 20 times 8 hours for that 1 day, $160. that would be part of the damage order. It also includes actual economic damages. So aside from the unpaid wage, if there are other actual economic damages to the employee, that would have to be included as well. Now, the law also permits DLLR to exercise some discretion. And so in theory, the DLLR can include the penalty, a penalty that's 3 times the value of the employee's hourly wage for each violation. So that 160 could be tripled, and that could be included as well. And in addition, and this is probably the most significant penalty in most instances that could be included at this stage, is a $1,000 per employee penalty for employees that are, counting the number of employees for which the employer is not in compliance. So if there's a problem with the math and it's only one employee, not that big a deal. If there's a problem with the system, for example, no employee in the company is getting notice of their sick or safe leave balance, and there's 50 employees in the company, then in theory the DLLR could issue a $50,000 penalty. So that's why it's very important to be on top of the systemic the system-based functions of the law. Now, if the employer does not comply with the order issued by the DLLR, then there's the potential for a civil action either brought by the commissioner of the DLLR or by the individual employee. And if a civil action is pursued, the risk to the employer goes up. So obviously this is not going to be something that employers are going to want to have happen unless they feel as though there's a very strong defense and there's a strong reason to continue to challenge the DLLR's finding. Because if an employee brings a private cause of action, the damages can include 3 times the value of the employee's unpaid leave. It can include punitive damages, attorney's fees, injunctive relief, things that are not included until you get to that stage. So really, if you can't tell it already, I think the purpose of the penalty scheme being structured in this way is to stack the deck against employers and to really create a lot of leverage from an enforcement side on employers to force them to the bargaining table and encourage them to compromise as early in the process as possible.
All right. So what should we do now? What kind of actions should they be taking? The first is obviously to review the law and learn the requirements, some of which we've talked about here today. Try to give a good overview of the basics of the law and what it requires. The second is to review your current leave policies if you have them and determine whether the existing policies are in compliance with this new sick leave law. If they're not in compliance, or even if you have a question as to whether or not they're in compliance, then you need to figure out what the steps are that must be taken to make those policies become compliant, to avoid any of the penalties that Russell was just speaking to.
So on that point, I think one of the things that we've seen a lot of already in the last week and a half is employers will have policies where they provide general leave. They don't really care what the employee takes it for, and plenty of days, 15 days, 20 days, something like that. But they don't have the accrual consistent with the law, or they don't provide at least 40 hours up front, or they'll have accrual but they won't have carryover. So I think a lot of what we're seeing so far is that employers will need to make some changes, or they'll be out of compliance in the more mechanical ways than in the the big substantive way of how many hours are preceded, or do I allow employees to take leave for these types of absences.
Right. And so obviously those policies will need to be updated, and if you don't have policies regarding sick leave, as many employers don't right now, then we'll have to have those policies drafted and make sure that they are compliant with the current law as it is. And as regulations come out and as this evolves, as all employment laws do, we will do our best to push out content to make sure that the members and other business owners are aware of the new regulations that may affect this law.
So one other thing we should touch on before we get to all the questions here is that this is still a fluid situation. The DLR has not issued its regulations yet, and even once it issues draft regulations, there's still a process by which they could be revised and have to be reviewed, and it's going to take a couple of months before they could even be in effect anyway. So that's kind of a best case scenario. In terms of when this law is going into effect, the state constitution states that when a veto is overridden, as was the case here, the law goes into effect 30 days later. That would mean that this law is set to go into effect on February 11th. There's supposed to be a hearing this afternoon, which was bumped up to yesterday, regarding a bill by one of the, I believe, the chief sponsor of the sick or safe leave law, to create some sort of breathing room and an extension. My understanding of that bill is that it was going to provide for an extension as to the date that the commissioner would begin enforcing, but it wasn't going to change the actual effective date of the law, and therefore it was not going to change, when employers in theory would have to be in compliance with it. I think there's, we're talking about a political process here, so there's people that want to pass through an amendment that's very narrow. There's people that would like to push back on some of the substance of the law. So we don't know exactly what's going to happen. In fact, I know there was one of the senators yesterday, or at least one of the witnesses during the hearings yesterday, was pushing for a July 1 effective date because most of the municipal and county governments operate on a annual budget that begins on July 1, and it would be hard to shift gears mid-year. Also along those lines, as I mentioned, it's going to take a few months for us to have regulations, and we'll do our best to answer a lot of the questions we've gotten, but not surprisingly, a lot of the questions are geared on definitions and what does this mean, and how do you resolve this ambiguity in the law. And we can tell you our best guess, and it's more than a guess because we're interpreting and analyzing, using our legal know-how. But ultimately, there could be regulations that, and we would expect there would be regulations that address some of these ambiguities.
Okay. All right. Turning to some of the questions. Russell, if a company chooses option 2 for the carryover, if the company chooses that to front load the hours and give the employees the 40 hours of sick leave up front at the beginning of the year so that they don't have to carry over any hours into the following year, then what would they do for new hires that come on board after the start of the year?
So that's exactly one of those questions that I think the regulations will likely provide some guidance on. But here's my thought as of right now. I don't think the law is entirely clear that you can prorate that. So that would be the option, is if someone comes on board on July 1, they would get 20 hours because they're there for exactly half the year, and they wouldn't earn the first 20 hours. I'm not sure that that's so clear in the law and that that's necessarily permitted. And given the relatively low risk of providing a couple extra days of paid sick leave, I tend to take the conservative approach for now. That being said, I think this is going to be a short-lived problem, because if you take that approach now and you hire someone in March and you give them the 40 hours right up front, by the time we get to June or July, I would expect that we would have regulations that give us guidance on it. And if the regulations make clear that prorating is okay, then we change the policy and we start prorating then. If the regulations don't give us guidance, we take the conservative approach to avoid the $1,000 per employee penalty.
Okay. Somebody had asked about the ability for the employers to require a verification that the leave was being used appropriately, and the law states that that can be done when the leave was used for more than 2 consecutive scheduled shifts. So you can't require that verification if the employee is only out for 2 days or 2 consecutive shifts. But once they reach that 3rd consecutive shift, that's when you can request that verification from the employee. Russell, how would you recommend employers handle situations where they may have a lot of different categories of employees, to where they might have, part-time seasonal employees and full-time exempt employees? Would it be a good idea or a bad idea for that employer to maybe apply option 1 to some of the employees for the carryover and option 2 for the other employees? Do you see a problem with that?
Not really. So I see the issue being, the statute doesn't talk about whether you can mix or match, which seems to me to be tacit permission to do so, as long as you're compliant with the minimum requirements of the statute. And I think for certain employees, it would make sense to do things differently, and as long as you're compliant with the minimum thresholds of the law. The only thing that you really have to be conscious about when you start treating employees differently from one another is running into discrimination claims. And generally speaking, if you're classifying, if you're providing different benefits, which is what the leave would be, based on different job titles and job classifications, you're probably going to have nothing to worry about with respect to a discrimination claim. It's where you start providing certain benefits to one group of people or another, where you could run into a discrimination problem. And we just don't want to accidentally back into that when we treat employees differently.
Okay. We're receiving questions about what does the term family member mean. And the statute has specifically defined how family member means, but as an overview, it's a biological child, adopted child, foster child, or stepchild of the employee, a biological parent or adopted parent or step-parent of the employee or the employee's spouse, the employee's spouse or an employee's spouse is a family member for the purposes of the statute, and as is grandparents, grandchildren, siblings, and so those are essentially how family member is being defined by the statute. Russell, are overtime hours required to be counted for the purposes of the accrual method?
Yes. Yeah. So for non-exempt employees that you would be tracking their hours, the hours are earned per, it's 1 hour for every 30 hours worked. There's not a per week cap as to you can only earn up to 1 hour for every 30 hours, up to a total of 40 hours worked. It would just be based on the pure number of hours worked. Now, of course, if you do the math on this and you earn 1 hour for every 30 and you had a cap of 40 hours earned in the year, and someone's working full time, that's going to get them into like June or July. So at some point, you stop earning more hours because you've already earned them for the year. And if you worked overtime, you would just get there faster.
We're being asked if an employee is denied sick leave and they still are out of the office and not working, is the employer required to pay that employee anyhow? And the answer to that, like a lot of questions, would be it depends on the situation. But generally speaking, as long as you have a compliant sick leave policy that's compliant with this new law and you are correctly applying that policy and the employee is then appropriately denied sick leave for whatever reason, then they don't have that sick leave to take. So if there's no other leave that you have available for them to take pursuant to your policies and they're out of work, you can take, provided they're an at-will employee, disciplinary actions up to and including termination for that employee missing their scheduled work. However, I say it depends because depending on the situation, you may be exposing yourself to some sort of discrimination claim or retaliation claim if there have been particular circumstances with respect to that employee. So without knowing any of those details, generally speaking, as long as you're correctly applying the policy and they don't have that leave accrued and available to take, then no, you shouldn't have to pay them for that if they are out of the office and not working in violation of the policy.
So April, we're getting a number of questions about how sick or safe leave interacts with existing state and federal laws, such as the FMLA. What are your thoughts on that?
Well, my thoughts are that if the existing federal FMLA applies to your business, then you would need to have a leave policy that is compliant with both the federal law and also the Maryland law. I don't see anything in the new Maryland sick leave law that would be counter to the FMLA at this time.
Yeah, and along those lines, I think it's perfectly reasonable for these to run concurrently. So I don't think it's 12 weeks of FMLA leave plus 1 week of paid sick leave. I think you would want to address this in a written policy to make it clear that they would run concurrently, just like other form, for example, short-term disability or requiring employees to take PTO and burn off their PTO as part of their FMLA leave. I think you would want to incorporate this in much the same way.
Well, what if FMLA doesn't apply to your business, but you have a really generous PTO policy and you don't require employees to specify whether they're taking that PTO for sick leave or for just vacation purposes? Would you still recommend that employers do the things that we've mentioned today in terms of tracking sick leave and making sure that they're affording those employees the sick leave hours that they're required?
Yeah, so in my opinion, I think there's two schools of thought that are starting to form on this. One is moderately conservative and the other is ultra-conservative. And so the ultra-conservative approach would be, let's say you have a policy where you have general leave. You can use it for, the employee can use it for whatever the employee would like, of up to 15 days. The ultra-conservative approach would be, let's not touch that. Let's leave it exactly how it is, and let's just add in an extra 5 days of sick or safe leave. The state's supposed to craft a model policy. We'll just adopt that or something like that, and we'll just have this separate bucket of paid sick or safe leave or unpaid sick or safe leave that will count separate from the general PTO that we've always awarded. That's ultra-conservative, and that requires providing the employees with an additional 40 hours a year of leave. The alternative would be to take the existing policy, which is the 15 days or the 120 hours worth of general leave that employees can use for whatever purposes they would like, and revise that and edit that to make it compliant with the law. And as I alluded to earlier, that might be as simple as tinkering with accrual or carryover. Or it might be something basic like, well, typically we have employees accrue their time over the course of the year, and we don't have carryover, and now I have to pick one or the other because the law says I have to, and taking maybe the minimum 40 hours as required by the law, awarding that on the first day of the year, and then accruing the rest over the course of the year so that you can be compliant with the law, still have employees accrue most of their leave, but not the minimum 40 required by the law, and then not have carryover at the end of the year. So some of these solutions are going to really require you to, to pop the hood and look at the engine and figure out exactly what tweaks can be made to make this change and make your policies compliant with the law in the least disruptive way possible to your ongoing business.
Okay. We are getting a lot of questions about whether or not we will have the PowerPoint and also the recording of this webinar available. We will, and we'll be happy to send that out to the attendees of today's webinar. So we'll make sure that you all have that, and then that way you'll also have an email from us, so you can feel free to respond with any specific questions that you may have. This is an interesting question. If an employee carries over 40 or close to 40 hours into the following year, can the company then stop the accrual until the balance falls below 64 hours again?
I believe they can. So the way I see it working is, let's presume someone earned 40 hours in year one and they didn't take any of it. So on December 31st, they have 40 hours that would carry over into the next year. So they're starting January 1 with 40 hours in the bank, and then they start to accrue, and they get about 3 or 4 months into the year, and they hit the 64-hour cap. I think you can cap it at that point because the law says you can put a limit on the amount of hours in the bank. However, if they then use a day of sick leave and they go back down to 56, for example, they would then start accruing again, and they could accrue up to 40 hours over the course of the year. To be frank about it, I think the law is poorly drafted in this respect because it talks about these caps and it doesn't really talk about the interplay between them. So I'm basing that answer on the fact the law says you can have a hard seal, and you would have to have a policy that says this. You can't just do this, but assuming you have the right, written policy in place, I think you can shut people down from accruing more sick leave at 64 hours total in the bank, even though the law says an employee has to be permitted to accrue up to 40 hours in a year. I think the limit on the hours in the bank would take precedence over the accrual requirement, because otherwise the limit in the bank wouldn't make any sense, and
right.
You wouldn't need that.
I agree, and I also agree that again, all of this would need to be in your policy. So figuring out how you want to implement this policy in a way that will be compliant with the law is important, and making sure that it's clearly communicated to the employees and the supervisors and HR folks who are going to be tracking this is also equally as important. So we try to answer as many of the questions that we could that I think would apply more generally across the board. And we do have some more tailored and fact-specific questions, and we will follow up with those of you who we haven't been able to answer those questions individually, so that way we can make sure to get you those answers. And like I said, we will also be distributing the PowerPoint and the recording of this webinar to everyone. So please feel free to follow up with us if you have any questions. We know that this is a bit of a frustrating process for business owners because it's a change and it's new and it's not as clearly drafted as I think that we would all like, and it's obviously creating a burden on employers that didn't exist before. So we just want to make sure that we avail ourselves to all of you to make sure that we can help you through this and get everybody on track with the policy and an implementation of it to try to make this new law be as smooth as possible for everyone.
Yeah, and as a kind of a general takeaway for where we are right now, obviously there's some more detail and nuance in the statute itself that we didn't cover today, and certain industries like the restaurant industry and to some extent construction and employers with CBAs, collective bargaining agreements, are going to have some slight deviations from this, and or some nuance to it. But the general point I want to make today is that you're all doing the right thing by getting up to speed and learning as much as you can about what we know about the law right now. it's a fluid situation, so we have to be somewhat flexible. But I think the right things to do right now are to understand the law, understand in general terms what you might have to change and how you would go about changing it to get into compliance with the law. And what I've told clients thus far is that I don't know that we want to make a change and we want to change your policy today when the effective date of the law could change, or or something more substantive could change in the law. We want to be prepared. We want to go right up to the doorstep of implementing a new policy, but we don't necessarily want to roll it out any earlier than we have to. And for those of you who dealt with the potential change to the salary basis test in the Fair Labor Standards Act a couple years ago, people made changes. People gave employees raises to bring them into compliance with what everyone expected to be a change in the FLSA, and then that change didn't happen at the very last minute. So across the country, probably millions of dollars of raises were awarded to bring employers into compliance with the law that then did not come into effect. So while I don't think that's going to be the case here, and we are going to have sick or safe leave, some of the details might change, some of the effective dates might change. So I think we're at this point where our counsel is be prepared, be ready to go, but let's wait and see what happens. And in the week or so leading up to February 11th, that would be the time to roll out policies. That would be the time to officially make these changes. But as April said, as you go through the process, you are going to need to change your policies, because even if you had everything compliant, I still think it's going to be important that you include references to this law in your current leave policies and make clear that leave is permitted for these requirements, and you might want to incorporate some of the notice to verification requirements into your written policy. So I think there's going to be work for literally all employers in the state of Maryland to do on this. And as you're going through that process, feel free to reach out to us if you have any questions or you need any guidance or assistance. Thank you all for joining us this morning, and good luck to you as you try to remain or become compliant with this law.
Thank you. Have a good day.